Everybody, I'm Beverly Porter, coming to you from the Dan Godwin Center and the ARC of Whatcom County, and I want to welcome you to this Establishing a Guardianship webinar we're holding today. I want to first let folks know that we are recording this webinar to be able to share it and use it with other educational events. So I wanted to give that information first up so that you're aware of that. And I also want to let folks know that this is one of many events that are put on through the ARC of Whatcom County and through the Parent Coalition to provide information, education, trainings, and support throughout Whatcom County for individuals with developmental disabilities of any age and their families and caregivers. So whether you are connected through birth to 3 settings, or if you have a child who is in the school age, or you have an adult, and that's why you're here to talk about guardianship. We would love to connect with you and let you know about other things that are coming up in our community and opportunities to get involved and receive information and resources. So you can go to arcwhatcom.org and see more about all of our programs here at the ARC. I encourage you to sign up for our newsletter and e-alerts so that you're aware of other events that are coming up in the community. And I'm going to go ahead and start then and talk a little bit about guardianship. So many of you were receiving information previously that you needed to go to Whatcom Superior Court to purchase a guardianship packet. And that is a pretty vast set of paperwork. So it's about 123, 124 pages of information from Whatcom Superior Court. So hopefully you have that in front of you, and that is something that we're going to be able to work through the initial parts of that today. Guardianship, because it is a very serious and a restrictive process for an individual of any age with any disability or without, there are a lot of settings and there are a lot of restrictions and concerns and processes that we have to go through at a variety of steps in this process. So they're meant very specifically for providing care and protection, for being able to give some oversight and some support to an individual who may have challenges in being able to participate in legal, educational, medical, financial settings. So when guardianship is granted to a person, not only do we have to prove that somebody has incapacity or that they are in need of support and protection, but as well the person who wants to become guardian has to show that they're able to take part and participate in the responsibilities and the reporting that they need to, that they're required to. So establishing that guardianship does really restrict somebody's ability to exercise certain rights on their own. And it really should only be considered after looking at other alternatives to guardianship. So we do encourage people to look at power of attorney for financial or for medical. And we also encourage people to look at things like representative payee, supported decision-making, say with a social worker or some counselor, and see what other options may be more appropriate and helpful for you and your family. But the role of the guardian really is to advocate and to support the rights of that person, help make the best of that person's ability with minimal restrictions as needed, really. The guardian has a great deal of authority, and their duties of protecting the health and the finances of the person need to be balanced with really minimizing the impact of restrictions on that person's life. So that's kind of a big picture about the guardianship and how it's viewed as taking away somebody's rights and how that is a pretty serious process to go through, which is why our court system does this. And as you were finding out in the very beginning, even purchasing the packet, there are a great deal of layers and bureaucracy to move through. That is for the rights of the person, that any person who has somebody who seeks to have guardianship of them has the right to due process in the courts. So this is why that process is encoded through the court system. So I have opened up my screen. I'm sharing my screen that shows what we're really starting with today is the initial portions of establishing a guardianship. And I have gone through the entire packet and done something where you can see at the lower right-hand corner of that page, it says 002. I've actually gone through each page of the packet and numbered all of them so that I have an idea where things are at. And we will email this packet to you as well. This guide that gives hints and a key and a process for you to be able to fill in and complete many of the forms. By numbering the pages, it allows me then to find the various forms that I need in order to work my way through those. So what I'd like you to do is, in your packet, be able to turn with me to page 8 in the packet, which I am also showing on the screen right now. And this is the very initial instructions for establishing the guardianship in Whatcom County. And as you can see, I have put page numbers halfway down the page where it says complete the following forms. I have listed what page numbers that form is located in your packet from the Superior Court. We are going to process through pages 1 through 28 basically this morning and give you a start to be able to get the rest of those forms completed. The process initially, those first forms are allowing you to ask the judge and say, I am petitioning for guardianship of a person, and give the vital information that judge needs in order to even appoint somebody to investigate the guardianship. After that portion is done of having the petition, then the family member is notified and a guardian ad litem is assigned to the case. So these forms are part of that due process that begins this lengthy, usually 6 weeks to 2 months, this entire process takes. And that has nothing to do with how loving and caring and protective you are as a parent. It has everything to do with just going through these complete processes. In general, the steps that you will need to take are, first of all, purchasing the packet as you have. Then, as you can see on page 8, the next step is actually to take this mandatory lay guardian training. The lay guardian training means that you're not a professional guardian. There are people in the community who have to take further education and continuing their learning to be able to provide professional guardianship to people who do not have a guardian. Then that next step is to complete these following forms. So from pages 11 through 28 are what we are going to complete today. This process, as I said, does tell the court that you want to have an investigation of a person that you believe does not have the capacity to participate or to be able to handle their health and welfare as well as their finances. And so petitioning and starting this process then has the next step begins when a guardian ad litem is assigned to the case. The guardian ad litem is a temporary guardian. They are somebody who basically has additional training. Many of the guardian ad litems are trained in law and are attorneys. They want to come and meet with your family member and talk with them about what this does mean in terms of the process of losing some or many of their rights. And that guardian ad litem is as well as going to talk with you about the responsibilities that you are taking on as a guardian. They would then prepare a report that is going to go back to the court so that the judge can review that information. And as well, they are going to ask you to see for your family member to have a medical appointment that does provide some information to the court about the person's disability or conditions and the level of incapacity or challenges that they do have. So that can take another month to get those parts completed and to then do some more paperwork. And then a hearing is held where the court has received all this paperwork and reviewed it all, and then you and hopefully your family member will attend the hearing to be able to stand before the judge and then be assigned as a guardian. So a person the person who is incapacitated does need to be deemed by the court or seen by the court as somebody who does need protection and support, and that their rights should be to some level restricted, and then decide whether or not you indeed should be that person who is guardian of them. So that's kind of that big picture piece. And as I shared before, it doesn't matter how loving or caring you are as a parent and how much you do know about your family member. That happens in some ways of how you can fill out these forms and present information. But the process still takes some time, and it doesn't go faster for anybody because of the level of care they have. So I want to share that with you as a person who went through the process myself. I'm guardian of my adult son, and it felt like it took forever to get through. And then when we were in, it was like, oh, great, we've got this made. So now I can serve as his advocate and his support. So I'm going to take my screen back up to the very beginning of that packet you got. And this is the first page, which is actually in a landscape setting. This is a key. And I'm going to just walk through some of these descriptions so we can look at what letter in the packet. I may have put the letter A on one of the pages, and that is because it asks for the name of the alleged incapacitated person. So again, that incapacity is what is being questioned by a person and by the court. So with this form, we can work our way down and look at the letter and what that indicates and talk about what those pieces mean. So the letter A does define your child's name or the person that you are, the date of birth of that person. And generally the folks that we are working with, if you have a family member who is about to turn 18, that's helpful to know because the court does look at guardianship differently between minors and between adults. The letter C is for the case number. And this number is requested in multiple places and in fact on every form that you will ever turn in for the court around this guardianship. That case number will not be assigned until we take this first section, those first 28 pages that we complete to the court to file the petition. That number usually begins with the year, so yours probably will be 20 and then has other numbers behind it. So you may find yourself after some time that you have memorized the case number. You will need that continually. The letter D would be for you or the name of whoever that person is petitioning to be guardian. The letter E for the age of your child. Even though we gave the birth date, we have to give the age as well. And then there's some other information around addresses. So section F would be the address of the person that you want, the alleged incapacitated person or your child. The letter G is for a post office. Some people do have separate mailing and home addresses. So if there is a post office box associated with that person, you can list that here. And then we come to letter H and I, which are a little more specific and personal. The letter H is where we would enter the diagnosis or the condition of our family member. And understanding that this is information that the judge will see and be able to have an idea, what does that diagnosis mean? Like if I put in Down syndrome, a judge may look at that and know right away, that means that somebody has some intellectual disability, and that would help a judge understand a little bit more why you were petitioning for guardianship. You can also list appropriately whether or not there was autism, cerebral palsy, any sort of intellectual or cognitive disability, if there are fetal alcohol effects or a traumatic brain injury. Again, and I would just go with the diagnostic criteria, be able to be simple and clear without going into detail. Because this is also, these forms and this information is also open for public review. If anybody else wanted to come and say, hey, I really want to know if Beverly's doing a great job for her child, they could request to see my original petition to the court. And so I want that information that's there to be respectful of my child as well. The letter I is around the degree of incapacity of your child or of your family member. This is where you may want to give a little bit more information on how that condition or diagnosis is impacting your family member. Does it have a great deal of impact on their ability to communicate their needs, whether or not they can hear well and understand? Does it impact the way that they're able to communicate themselves and have others hear and understand what their concerns or questions are, or even requesting food or support with hygiene? Does that condition or that diagnosis have an impact on their decision-making, on their judgment around safety and hygiene? Are they able to manage their personal care, be able to keep an eye on their finances? So those are some ideas of ways that you may frame what the incapacity is. So again, so the judge can see these are legitimate concerns. Are they ones that then do make somebody eligible for a guardianship? So those are areas where it may be easy for you as a parent to get bogged down thinking about how to quantify and describe this for somebody. So that key at the very beginning, I hope, gives you some ways to be able to be clear and be direct, but also be respectful of your family member. Then the letter J, we get back to some simpler things. So your address is also requested on there. K, we've put in your age. And they do ask, what is your relationship with the person? So the letter L is around your relationship with letter A. So there's also an opportunity in one of the forms where we put the letter M for blood relatives. And I've put this idea there that if you have an aunt or uncle, if there are cousins or extended family members of the person you'd like guardianship, who has kind of a lifelong knowledge and relationship with them, who would understand a little bit more about the personality and the interests of that person. This could be somebody who you may not want necessarily to be a standby guardian or to make a great deal of decisions, but could be somebody that the court could rely on either immediately or down the line to be able to get input on how that person is doing. So if there's someone in particular that you know could really be an advocate and is somebody you trust, they may be somebody to list on here as well. But you don't have to list every blood relative. It's a matter of really honing in and thinking about who would be a resource around those kind of questions. The letter N has to do with, does that person live with you? And if they don't live with you, if they live in an adult family home, a group home, some sort of nursing facility, then that's where to answer to that. But most of us who are applying for guardianship, that our family member does live with us, so you don't need to fill that section out then. The letter N is for areas of, or the letter O, excuse me, is for areas of protection. And this is one of the questions that is asked later on, trying to, again, define down a little bit more, where does somebody need support? It could be that somebody's communication is really challenging, and so we need to be able to protect them and support them in ways that they can be heard and have more time for folks to listen and understand them, how they're able to communicate their needs. So areas of protection could be quantified in the ways of talking about safety or judgment and decision-making. Somebody's needing protection and support in self-care, in their daily needs. in their nutrition and hygiene, and in their mobility. So those, again, are some phrases or ways for you to be able to look at how can I describe my family member's needs, and in a supportive and a respectful way that the court would also understand how they may need support. The letter P is a description. Actually, we put in many times the court is asking if a client is going to pay filing fees or other court costs. And the phrase that we put in here is the client is indigent or unemployed. So because the person that we are seeking guardianship over does not have any resources, this gives room for the court to waive the filing fee and to cover the costs of the guardian ad litem to some degree. So in this way, then, this process is accessible for folks of many levels of economy. And so being able to say client is indigent and unemployed is very helpful. And the letter Q is for the GAL, the guardian ad litem, and that is that temporary guardian who does provide that investigation and report back to the court. So the last line on there is, oh, and Monica's raising her hand. Or you are clapping.
No, I was raising my hand. I had a question about the client is indigent or unemployed.
Yes.
What if they have like a part-time job that is, minimal hours? Would you?
That's a great question. Yes. So one of the ways that the court also looks at this, and when we get into the forms, you can see the detail, is if somebody's estate is $3,000 or less, their filing is not seen as a big deal. So that would, even if somebody was minimally employed, that would be another thing to put, because their resources are incredibly limited. That's a great question. Thank you. The last line, it says C sealed CNRSE, and I know there's a lot of S sounds in there. That refers to a form that is a confidential form that we can put phone numbers on. So every form, it seems like every court document that needs to be filed asks for names and phone numbers, email addresses, addresses, that sort of thing. We can keep the phone numbers of ourselves and our family members on a confidential form that is sealed with the court and is not part of any publicly accessible information. So on any form where it asks for a telephone number, you can write in this phrase, C sealed CNRSE. And as we move through the packet, you'll see where I have also put that information in. So I'm ready to roll through the pages and move on to page, I think, I got to see in my numbers here. Make this a little smaller for a moment. I believe I'm going to page 11. So let's see here. That's 9. Okay, it looks like we are at, yes, page 11. So page 11 is one of the first forms, and this is called a case information cover sheet. So you can see in the red letters, I'll make this bigger again. Is that better? Great. So I've put in Whatcom County for the Superior Court, and where it says case number, the letter C, that's that case number you still don't have yet, so you'll leave that blank for now. The case title would be a guardianship. And under attorney name, where it says D, you are the attorney. This is a what is called a pro se case, where you are acting as your own attorney in this. So again, you can see the letter C and D. This takes you back to that key of what information do I put in what line. Partway down the sheet, I've also put a red check under GDN or LGD, and that has to do with a full guardianship of a person or a limited guardianship. This is a personal and a family issue to be able to look at of, do you have limited guardianship of your family member, or is it full guardianship? Full guardianship does remove and restrict people from being able to exercise their rights. So there are limited guardianships where people have the ability still to make decisions around where they live and how they're voting. Not just how they're voting, but that they actually get to vote. So these are some of the rights that people can retain under a limited guardianship. So that will be something that you will talk with the guardian ad litem about or have an understanding of beforehand. So I'm going to go down, so then you don't have to do anything on page 12. And I will slowly move down to, okay, I'm on page 13 now. And this is the form that I referred to before. This is your CNRSE. This is your confidential numbers form that is sealed with the court. And so as you can see on this form, I filled in the letter A in the guardianship of A, your family member. Then it says over on the right, it says the number is C. That's where you'll put in the case number that you still don't have yet. It asks for the date of the birth of person A. And then I just put a few letters in the table down below. So the name of the incapacitated person, A, and your name as guardian. If you've already chosen who or have an idea who will be standby guardian, any other people that you do want to add to this form, this is where you can do that. It is okay to leave things blank. If there are questions that you've not discovered the answers to yet, or that you want to talk more with the guardian ad litem or with the guardianship facilitator, once you've got these forms fully complete or partially completed, being able to find out a little bit more about the process here. I really encourage you to go ahead and leave things blank if you have some concerns and you want to find out more about what to do here. So that's where you would put any phone numbers that you wanted to keep private, and then at the bottom, sign it and print your name. And after the signature and printed name, often you'll see a line where Washington, the WSBA is the Washington State Bar Association, and CPG is a coalition of professional guardians. Don't worry about putting a number or anything else there. When I leave it blank, you can leave it blank too. So that is that confidential, that CNRSE that now when you see that on every other form, you'll know, oh, that's the only place my phone number is going to go, is on that form. So the next page, page 14, I think. I have to check here. Yes, page 14. I'll scroll back up. Sorry about that. This is the petition for guardianship of a person and or estate. So this is really how the court hears in the very first time we have a concern that person A does have some incapacity and has some concerns. So as you scroll through this, you can see that we will put the name of our family member. We will add the case number once that's given to us. So you'll leave C blank for the time being, but then in section 1, where it asks for information about the alleged incapacitated person, that's where you will start to put in the name of your family member, their age, where they live currently, and if they do have a post office. So again, with the A, E, F, and G, you can just start to fill in those blanks and know how to answer that form. The petition of guardianship, this is one form that is used for people of all ages. So section 2, where it says information concerning guardianship for a child under 18, this is not something you will fill out. Even if your family member is a minor right now, that you are applying for guardianship of them as an adult. So even if they're not 18 yet, you'll go ahead and leave the rest of that page blank. And we will move on then to page 15. And down to the nature and degree of the alleged incapacity. And now you can see that that is a really short line. There's not a lot of room to write things in. So that's why it's good to have thought about the letter H and I there. The diagnosis or the condition you're specifically referring to of that person. And it could just be that you will put cognitive disability. And keeping it simple also means that you don't have to put every single detail, and you can fit the information in there. I once tried to give a lot of information to the court and typed it in a really small font, and it got sent back to me to take it smaller. So I've learned by making those mistakes and trying to be fully accurate instead of just being simple. So then the letter A or the letter I there is for the degree of alleged incapacity, and that's where you may refer specifically to some of those deficits in judgment, safety, personal care, how somebody is able to manage their finances, those kind of concerns. In this next section, this kind of explains why we put that other piece later on about the client being indigent. This asks for the information about what kind of property or ownership your family member has. And your family member probably does not own real estate, stocks and bonds, have a mortgage of some sort, own a great deal of furniture, or have other personal property. I've put an estimate in there under bank accounts that it could be somebody has a savings account of $50 or something like that. Because this form covers all sorts of guardianships, it asks for many of these details. If I were seeking guardianship about a relative of mine who was older and who had an estate and say $100,000, the court would want to know that so that they could make sure that I actually was a good steward of those dollars, and those dollars were only used for the benefit of the person I had guardianship of. So there's some pretty extensive pieces around information on property and resources that may seem like it's a little over the top, but it's not in some of these circumstances. But this is a really good place to go ahead and put all the zeros, because your family member doesn't own something that is kind of the rule that I've seen to look at is if they have something that they could go out and sell for $1,000 or more, then that's something the court would want to know about, because that meant that they would have the potential to purchase things or to be able to access some sort of supports. And the other opportunity that they would have too is, let's say they did own some antique furniture and they had somebody who was selling that on their behalf, but that person was actually exploiting them. So that's where wanting to know about the value of property that somebody has in order to ensure that that person is not exploited or taken advantage of. The next page then goes into, are there any existing or pending guardianships? And that if somebody was older or if you'd moved here from another state, we would put information in there as well. So on the bottom of this page is about the nominee, and that's you. You are the person who would like to be guardian to your family member. So you put in your name, address, and there where it asks for telephone number, you put the C, the sealed CNRSE. So you're hopefully memorize this one and start rolling that one out on your paperwork pretty easily. It also does ask your age and what your relationship is to the incapacitated person. And then in that last line there where it says the nominee or proposed guardian has or has not completed your lay training, that's where you will have wanted to hopefully say that you have done that. I find that the training is a really helpful refresher to be able to look at some of the questions that have come up here and think about your responsibilities. So you will need to have that training completed, and if it's not completed by the time that you are appointed as guardian, it's something that will need to be done in the next 90 days. That is an online training, and that website where you sign up for the training is, I believe, on page 8 of your packet that we showed you earlier. So we are moving on to page 17, and we talked earlier about the names and addresses and the nature of relationships of persons that are most closely related to the incapacitated person. So that's the letter M in that form of yours in your key. And some information I added to there. Who really knows this person? Who really knows your child? Who could be a trusted advocate and stick up for them in some ways? So that may be a person that, whether it's in 3 months or 3 years or 3 decades, that if the court had some questions, they could follow up and have a record. Here's somebody who has known this person for most of their life, and we can check in with them on questions and concerns. And then at the bottom of that page is if your family member does not live with you, if they are living in assisted, some sort of adult family home, if they are living in supported living housing or a residential support of some type, that's where you would write down the name of that facility and then the contact information for that. And all that information can be put in this form. You can put the phone number of a state facility or a county facility of any sort in this. So the next section, as we move on to page 18 then, is asking a little bit about the reasons for petitioning for guardianship. I put the letter H there again because the reason has to do with the condition or the diagnosis of that person. And again, to try to be simple and recognize that there's not a lot of space to write there and that we want to be respectful of that person. So you could say, Joanne has Down syndrome and intellectual disabilities, and that would be very brief, and is not capable of managing finances, hygiene, health, those sorts of things. And then the interest of the petitioner would be a little bit more of you being able to answer personally. And so that's why I hadn't given very many prompts or ideas of phrases. You could feel that you could fill that out and say, as a parent, I've known my family member all their lives and understand their dreams and their wishes, as well as their needs and concerns I have about their safety. That was probably a much longer sentence than would actually fit there. So being able to think about that and have some ideas before you do jot something down. The next line, whether or not you seek to be a guardian, a full guardianship, or have limited guardianship powers over the person in the state, that would be where to write full or limited. And then the next section, letter D, talks about if there were any alternative arrangements that you have made before. Some families may have considered power of attorney and done representative payee and expected that their family member, as we all do, continues to learn and grow and gain skills and discover in their 30s that they actually do want to have more protection, or there's been some sort of regression. So that's where you would say if you did try some other alternatives, or why those did not work, those were not successful. Otherwise, that is something you can leave blank. And they ask many questions again. So areas of assistance, they ask again the nature and the degree of the alleged incapacity. So you have to try and fit H and I on that one page or on that one line. And then they ask again around those following, what are the specific areas of protection and assistance that might be required for your family member? And again, I go back to those with letter O. I tried to give some ideas around names and topics. And these are areas that I've seen these phrasings used within the court system of areas that they look at in terms of safety, judgment, and decision-making. Self-care, and inability to care for somebody, for themselves, for their daily needs and nutritional needs, mobility, communication. Those are all areas of protection and assistance that you may feel like you can put those phrases or those words related to your family member, whichever seem appropriate. And then the duration of the guardianship, many of the folks that I work with and talk with, that they are looking at guardianship continuing for the remainder of their family member's life. And so that's the phrase that I've put in there. You may look at yours differently and think about other ways that you would want to address that with the court. It may be something in talking with the guardian ad litem or your medical provider that they would give some information as well. And as we work our way a little further down the page, it talks about bonds and fees. And again, this is the same paperwork process that somebody would go through if you had, I mentioned, a rich uncle who maybe had a great deal of money. So at that point, the court would want some sort of bond to be established that would retain and secure some of those funds on behalf of this person. In this case, because the client is indigent, because they do not have resources over $3,000, we would write a bond in the amount of $0 is waived for the following reason, which is the client is indigent. And then nearer to the bottom of the page, it says, I put a red X, that the payment of the guardian ad litem's fees should be provided that they are covered by the county for estates that are valued less than $3,000. So there are less restrictions on the finances then, and that makes it very easy for the courts too. There's less paperwork for all of us. So that is the rest of page 18. The last page of that document then, page 19, is a summary that says that the petitioner, that's you, are requesting the following relief. And I've X'd those top 3 statements. You're requesting that the court appoint a guardian ad litem, that the court order the waiving of the filing fee so that you're not having to pay that, and that the court also direct the guardian ad litem's fees to be covered by Whatcom County. Then the 5th section, I've also checked that off, that an order appointing you, D, as full or limited guardianship of the person be waived, and then the bond would be waived and set in the amount of $0. So that is the remainder of that, and here's when we get to the fun part. So every form that you turn in with the court will have a very similar end to it that says that you're declaring that this is all fair and true and correct and accurate. Each form has been developed at a different point in time. So sometimes it'll say signed on the date and then the place. Other times it'll say signed on this place at that date, and it will move around where the phone numbers get asked for or the email address. So it's really a good idea to check on each form and make sure you're writing the correct information in that line. So this one is signed at Bellingham, Washington on April or whatever that date is and the year. There's room for your signature and then your printed name, D, the address, J, and then here for telephone number, I put the C sealed CNRSE. And then if you have an email address, you can certainly add that there. On other forms, the telephone number and that line is the last line on the bottom left as well. So again, just kind of thinking about that as you are going through filling these out like they are worksheets at school and thinking you're doing things really quickly. Sometimes it's good to catch yourself and give yourself a moment to look, because they do move the topic areas around. So that is the beginning of the petition, and that is what the judge will be able to review and say, yes, we should assign a guardian to a guardian ad litem to investigate this. The next form then is a notice of the guardianship petition, pardon me. And I'm not going to spend a lot of time on every single form here, but just show you that part where, again, we've given the letters for A is the alleged incapacitated person. C will be the case number once that is assigned to you when you do go into to file your forms. And again, filling out as much of this as you can prior to going to meet with in the court. The piece about this that I really like around this form is because this is also a notice that will go to your family member. So that might come as a surprise to you, but when the guardian ad litem meets with your family member, and even that you need to give this form to your family member, they will ask them, they will say, do you know that your parent wants to be appointed as your guardian, and that you will lose the following rights when that happens, or if this happens. So depending on your relationship with your family member, it may be something you want to have some conversation with them beforehand and talk about decision making, talking about what support and advocacy looks like, and finding out a little bit more about what that person really does expect. When I went through this process with our oldest, at the time, when he was 17 and a half, as a guy and as a 17-year-old, he and dad were just doing a little more conflict and friction between them around making decisions, things that are pretty typical for a 17-year-old, and not wanting to mess that up or create more conflict within our family. I talked with both of them about this process and said, I want to be his guardian, and I want to have that related to me being his advocate and his support and helping with decision making, and leave the family interactions and some of that friction out of it, so it doesn't feel like dad's saying you can or can't do this. And so we tried to separate that in that way. And that might be more of a problem in a family depending on gender, with different parents. So being able to recognize that before you go into this and think about how to process it and talk with your family member around this. So that's a really important factor. The rights have to do with being able to marry or divorce, to vote or hold an elected office, to enter into contracts, business contracts, to make or revoke a will, to appoint someone to act on your behalf, to sue or be sued other than through a guardian, to possess a license to drive, to be able to buy, sell, own, mortgage, or lease property, to consent to or refuse medical treatment, to decide who should provide care and assistance, and to make decisions regarding social aspects of your life. So those are everybody's rights when they turn 18. And we've just, as a society and as a nation, have drawn that line and said this is when somebody goes from their being a minor into their majority, and these are where they have their rights are expanded at the age of 18. My son was very concerned about what it would look like for him to be an adult and have all those rights. So the other part of the conversation we had around this was talking about a cousin of his, and talked about when that cousin turned 18, which rights had they actually exercised and which ones had they not exercised. They hadn't bought real estate. They hadn't gotten married. They did vote. So being able to make it real and meaningful and tangible to him was also really helpful in being able to use a family member to represent what it looks like to be able to access and exercise those rights. This next section is very specifically what the guardian ad litem is going to try to explain and talk with your family member about, but they have the right to their own counsel. And if they do want to have their own attorney, if they want to have a jury trial, if they want to make some changes at all in this is their opportunity as well to dispute the guardianship and the petition for guardianship. So depending on, again, your family member's understanding and their cognition, being able to talk with them about what this sounds like and what it may look like may be really helpful. And then the bottom of this page just asks for where you signed it at, the date, your signature and printed name, other contact information, and the sealed CNRSE. I want to pause at this moment and ask if there are any folks who had any questions they wanted to type into the chat, if there were some other things that have come up through these topics. And I'll take a moment to look here. I'm not seeing anything that's come up in chat. Let's see, there we go. Oh, okay, one of the questions that came up is, how early can you do the training? You can actually do the training anytime. I would recommend it within probably 2 months of when you actually turn in the petition for the guardianship, though. I think if you do the training now, I don't know if you have an 11-year-old, it may be more appropriate to wait a few years. You can go to that web address and request. You request a sign in or a login, and then they send you the information. So yeah, you could do the training and be able to see what that looks like. It's several different modules that you go through. I think there's 5 or 6 modules that lead through, again, explaining the process, talking about some of these rights, and as well the responsibilities you have as a guardian. And again, that training is for any lay guardian, and it covers all the breadth and spectrum of the possibilities around guardianship. Okay, so with the petition being turned in and that notice, the next form then, I think, is the order appointing a guardian ad litem. So this is that due process part and the structure that happens with the courts of having the right papers in the right place. Our courts are one of the oldest bureaucracies, and maybe the oldest bureaucracy in the world. And we rely on a system of fairness and justice that I think we all want to trust. And so this is part of that piece that just says we've got to have a form that says this and another piece of paper that asks for that to show that we've gone through the correct steps. So this is a form that the judge then is able to approve an order that appoints a guardian ad litem and says that, so actually the petitioner, you, D, have a real concern, it appears, around person A. So we're going to appoint a guardian ad litem to do this investigation. So this form basically says that the court finds that under 1.3, the guardian ad litem shall be a person whose name next appears on their registry. So they just have a list of folks that they will assign somebody from, and that's every county has a registry. And then I checked off 1.5 around payment of the filing fee and costs as well. That payment of the filing fee and the costs of a guardian ad litem would result in a substantial hardship upon person A because they are indigent. And moving on to page 23, 2.1, I put a red X there where the clerk's filing fee is waived. And then didn't put anything in again until 2.3 where it says the guardian ad litem Q is found. So that's where, once we know who that guardian ad litem is, their name will be entered there, and their responsibility then in that next section, X, it says they shall be appointed at public expense. And I've left those lines blank then about the dollar amount, because the court will be able to answer what the current costs are and what their limitations are. So then moving on to page 24, again, there's just a lot of information here. But again, this is that bureaucracy and the expectation that this process is fair and accurate and is able to give the person that you would like guardianship of the opportunity to make sure that their needs are met. So that just lays out every single responsibility of the guardian ad litem and the next things that need to happen. So we are, there we go, down to the end of this form then of the order appointing the guardian ad litem. This is the end of page 27. And here's where you can see, again, they've changed it around. Dated and signed the whatever day, the 1st or 13th or whatever day of the month. It doesn't ask for the city, so if you wrote Bellingham in, you're moving quick. And then signed by you, your name printed, your address and contact information, or C, the sealed CNRSE. So that is, this is all the stuff that's going to happen when you come in, meet with a guardianship facilitator, and you're able to file your forms and move towards this next step where the guardian ad litem is appointed so the investigation can begin. And then we move on to some of the next parts. And I'm going to pause there because we're through with page 27. And these were the, I'm going to scroll back up here really quickly, in a quick way, I hope. There we go. Back up to where we numbered things. Sorry, I forgot which page it is. There we go. So we have moved through this whole section of the first set of forms to do, pages 11 through 27, which were the information sheet, the telephone numbers, the petition for guardianship, the notice of the petition, and the order appointing a guardian. So those are all the original forms that you're going to be able to take in and begin and initially file all of these. This is when you will connect with Connie Long or the current guardianship facilitator at Whatcom County Superior Court in the clerk's office on the 3rd floor of Whatcom County Courthouse. And that will initiate your petition and get the ball rolling. And in many ways, the rest of the paperwork is not as complex or may make a lot more sense to you, but those sections for the rest of this packet are ones that you do not have to have fully complete yet. So I will take an opportunity again to check in and see if there are questions or things that people would like to have further clarification on. Okay, well, I'm not seeing anything coming up in the chat. So then what I would do then is I'll talk about the next section. And so once this is started up and you do have a guardian ad litem who is working with you, the next forms that do need to be prepared are a declaration that you have done the guardianship training. That form is included in your packet and it is a sample form. What has been happening since the online guardianship training is happening is that you will actually get something you should be able to print out when you complete that training. So rather than having a declaration that you've completed the training, you can actually just attach a copy of that certification from the state as one of your documents. So then page 4, I've put the page numbers next to where these different documents are. They're in a different order numerically than they are listed here. So I'm going to go ahead and scroll down to page 28. Oh, and I have a question. Let's see. Or not. Okay, that just disappeared, so let's see. So I'm going to go down to page 28, which is right here. There we go. So this is the declaration of service. And again, in this paperwork process, the court wants to know and wants proof that somebody actually does know that guardianship is being sought over them, or that they have been able to be served and be aware of what is going on. So not only is your family member supposed to receive this notification, also the guardian ad litem is supposed to receive the notification. And by completing this forms, saying that you have served copies of them to that individual and signing that is part of that process of proof, and to be truthful, to say, yes, they actually know what we're going through and what we're doing around this. So these are fairly basic forms. And again, this is something that if you have some further questions in this, beyond the name of the person and the case number, the rest of it will be filled in by you in terms of the day and time and what forms those were, and how those were delivered. There's multiple copies of that are in this packet that you received, because you do need to deliver them to a number of people. And then I did not go through and put the letter A and C, and where it says telephone number, C, the sealed CNRSE. My hope is after completing some of these forms that you'll have a better idea of what those answers are for you personally, and so this guide has brought you to a better place of knowledge in terms of being able to complete these. And as your responsibility as a guardian, to be able to understand what is expected of you and what kind of information you will need to continue to share with the court. So again, there are multiple copies of that declaration of service. So the next form in your packet, starting on page 34, is what is called the order appointing the guardian. And this is once all the information has come to the court and you are ready to go in for that hearing to be appointed as guardian, this is information that you will complete as much of it as you can once more of the paperwork is in. And then this is something that you will complete by filling in the name of your family member and the case number. And the guardianship facilitator will assist with this next section called the guardianship summary. This will be information that can be set when you do know that you have the hearing date, and then it lays out what the process is for your reporting and information that you need to continue to share with the court. The court asks, after you've been assigned as guardian, the court asks for an inventory, and that would be a listing of personal property, assets, resources of your family member, and it probably for your family member is just a savings account. It is not an extensive list of real estate and items that they own. It also asks for a personal care plan. And again, these are just within 90 days after you've appointed. The personal care plan is a pretty straightforward form of checking some boxes around how is this person supported? It also asks here about if somebody does lose their voting rights. And so if somebody is not retaining their voting rights, the county auditor is then notified. So this form also informs how the clerk's office supports this process as well. Based on the day that you're appointed, then this other process or other steps, there's the 90-day reporting in terms of personal care plan and inventory. Then you're also going to need to do a report and an accounting that happens sometimes at 1 year, but definitely by every 3 years is sort of the longest term of time that somebody goes without reporting. So your responsibility as the guardian is to be able to show this is what a person's needs are, and this is how that I am supporting and taking care of and protecting their needs. The reporting is fairly straightforward, and it's just asking what income there has been for the person, and then how any funds were expended to their benefit. And that's something that we can support you here at the ARC in terms of how to gather that information to be able to report that. So this whole summary is a list of dates, and there are things that you're going to want to put on your calendar at home or in your electronic calendar to come up. If you don't remember when 3 days or 3 months has gone by or 3 years, then you may be needing to update information with the court. You will be given what is called a letter of guardianship when you are appointed. And that letter will only have an appointment date plus 150 days. So, and then the letter expires. That letter may be something that a bank, a financial institution will want to see. It could be something that DSHS or a developmental disability administrator, case manager will want to see. It's certainly something that could be useful with the schools as well. If your family member is still enrolled in school and is continuing to have an IEP, having a letter of guardianship allows you to continue to have the legal role of an advocate and the support for your family member to be involved in that. So that letter of guardianship will expire after a certain date, and that's why you are required to continue to report on the condition of that person, how their finances are, and how they're doing. So that summary, those dates are going to follow you then for the remainder of the guardianship, and keeping you on track on where and when to be reporting. I didn't, again, put all the information, at the bottom of page 34, hoping that you are learning and seeing through this process how to complete these. But the incapacitated person would be the name of your family member, your name in that area. And just a reminder around the phone number that you can keep that private by saying, see the sealed CNRSE. One of the other questions that comes up at the bottom of page 34 has to do with a standby guardian. And that would be somebody who doesn't necessarily have any rights or responsibilities over the person, but is somebody that if there were something to happen to you, that they could step in on a temporary basis and either support somebody through if you have an incapacity in some way or out of the county or the country, or if we needed to look at who else could be appointed as a guardian. So the rest of the form is mostly going to be filled in by the court. It just is describing what the needs are of your family member. And this is something that, based on looking at the guardianship, the guardian ad litem's report, or even working with the physician, you can say a little bit more about that incapacitated person and their ability to be able to manage personal affairs, financial affairs, some of their capability, and the concerns around those. So I did not fill those in because, again, it refers back to like H and I around their diagnosis. It refers back to letter N on what are the areas of protection or areas of support that that person needs. The proposed guardian, that information, are there any fees and costs? And these will have been determined by the point that you get to the hearing. This will have been determined already, so you can complete that. Whether or not there's a bond, most likely there is not. Are there any restrictions on the individual's right to communicate and visit and have interactions and relationships with other people? And this is fairly rarely used, but if you knew there was a concern, if there was somebody in your family member's life who did have concerns that they may be exploiting or taking advantage of them, this is something to look at or to think about. Is there a way that I would want to have some sort of restriction or a restraining order against somebody, or just be able to put something in with the court? Does this give an idea? Let's say there was a neighbor 7 years ago who'd been stealing lunch or getting in the mailbox or doing some things that seemed like they were targeting a vulnerable adult or targeting your family member, and you thought they may try to take advantage of them in some way. So you could be able to give some information to the court here if there was a specific concern, so that if that person did come back again or try in some ways to interact or take advantage of your family member, that information could be there. And again, do they have the right to vote? And that's been a fun one for my son. He loves voting. And so being able to retain that right for him is something that he feels very confident and pleased to be able to do. And this is a way to really be able to support your family member in continuing to learn and grow in their life. So that might be something you really want to consider. So then the court would make decisions. So again, you could put in the name of your family member, whether or not it was a full or limited guardianship. And if the court is seeing that you are a fit and proper person to be responsible and appointed as a guardian, some of those limitations and powers that may happen on you, if there was some restrictions on your family members communicating and having relationships and connections with others, those could be listed there. And then it very specifically lays out what the incapacitated person's rights would be revoked or removed from them, restricted from them. And so very specifically can declare which areas a person may continue to have involvement and the competency to do, and which areas we are supporting and protecting them in. And again, it's just a lot of paperwork. If there has been a power of attorney, that is something that can be addressed here. And then it appoints the guardian and would state then specifically that you would have letters of guardianship that would be valid probably for a year, maybe even for 3 years at this point. There is an opportunity here where it talks about the lay guardian training. And for some folks who have not completed the training yet, they have to turn that in generally within 90 days after being appointed as a guardian. It would have information if there were a bond here, or if that bond is waived, and then lays out again the expectations that you will turn in an inventory and a personal care plan in 90 days after being appointed as guardian. It also gives more information here in terms of your responsibility, that you are required to report to the court if there's a substantial change in your family member's condition, or if they move, if they were to be in a different residence. So this is where the court's role in your family member's life becomes a little more obvious, that you're appointed as a guardian, but they actually, the state is in charge of making sure that this person is protected well, and that the state knows what their needs are. So if somebody did have, say, a stroke or a series of seizures or lost some mobility, a substantial change in somebody's condition would impact the areas of protection and support and advocacy that they did need. And if they were living somewhere else and a guardian ad litem or somebody else went to check up on them and couldn't find them, that would certainly be a concern as well. The designation of a standby guardian is another piece, and that is thinking about who would be somebody who would step in on your behalf and be able to take on this role, at least for a limited period of time until somebody else could be appointed. So that's a discussion to have in your family of who else could be trusted and who could be an advocate. My daughter at one point had said she really wasn't wanting to be guardian of her brother, and we had the conversation that it doesn't mean that she has custody. It doesn't mean that she has to live near or be involved in everyday activities. If she were to be a guardian as a standby guardian and she became guardian then, it would mean that she would have the legal power to advocate for him and to be able to step into his life and with care providers, with the banking institutions, with anyone else, be able to declare and define what his needs are and what he really wants. And I said, you can tell people this is what works and this is how things can go well for you. So a discussion in that way may seem like it's a long ways off, but having some other people who've had the conversation with you and can think about what would it mean to be involved and continue to be an advocate for my family member, and how can I do that? Then information on the duration of guardianship and how long a guardianship will last or when they will continue to perform duties. So if there are other people who do deserve information on the court case, that information is listed there. We move on to guardian fees and the guardian ad litem fees. So again, there's a lot of different things that can be filled in here that you are not going to need to. At this point, the court will have let you know if you're completing a report just at 1 year, or if you have 2 or not until 3 years. I was initially appointed for a 12-month term, and now I report every 3 years. So I have to really make sure I remember to keep track of that, because I don't want that to, I don't want my letters to expire. And then again, the court gives some information about how they're going to review reports when I turn those in and the dates around that. Again, the right to vote, so that information is included on here. That's the form specifically to appoint a guardian. And then this other information here is signed by the judge, your name, you are the pro se, you are the attorney, you're the person representing yourself, your address, email, and C, the sealed CNRSE for your telephone, our phone number there. We are almost through all of this. But the next page is the oath of guardian. So that, again, I did fill in some of the numbers on that, or the letters here to complete this. But again, this is a form that shows not only did the court appoint you, you get to say, oh yeah, I have been, I have sworn upon oath that I've been appointed and I will perform these duties and responsibilities according to the law. So this is something that you are signing and declaring in a court of law that you're going to meet the responsibilities that are asked of you to support and advocate for your family member. And so that shows that you do understand what your responsibilities are. These next 2 pages are what are called the note for motion docket again, and you would just put in the name of your family member, the case number, and this is similar to a cover sheet. It's a request to get on the schedule for a hearing. Most of, or almost all of the what they call family law cases are scheduled for Friday afternoons at 1:30 p.m. And so that is when guardianship, parenting plans, some of those other family law cases are heard and dealt with at that point. As we're in the time of COVID now, hearings are not being scheduled presently, so we will see what happens as that changes. That may be more that is done electronically or over virtual meetings. But I'm hopeful that, again, people will be able to go in and be able to be seen before a judge to have this done. And then you would sign and date and not put your telephone number here. And also it says certificate of mailing. This shows as well that you have mailed any of these documents to anybody else who did need to receive legal, who did deserve to receive this. So every time I turn my reports to the court in, I also give a copy to my family member and then to the standby guardian so that they can see that I'm keeping up on that record keeping as well. So I show here that I did send those to them, and I don't mail them anymore because I've been given permission by the court. They said, oh, go ahead and just hand deliver those since we all live together. But that's part of, again, that expectation that somebody else can see that I'm doing my job. My son does not want me to break the law. He'd asked somebody one time, he said, what do I do if the guardian ad litem is being a criminal? And so we talked about how he could check in with the court. And I also want the standby guardian to be receiving those reports, because then they have a better idea of, one, what is reporting going to look like? Can I do this, in 3 years or 3 decades? And also, what's going on with my family member? I didn't know we were keeping an eye on those things. So it informs them in another way about those expectations. And we're pretty much at the end here. I think there's one more page. And, oh, yes, that is the sample page. So it used to be you did not get a certificate emailed to you from the state to say that you had completed the guardianship training. So this is just a sample page. You can actually turn in the form or a copy of the form that you receive when you complete the training. So that's a lot of paperwork. And I thank you for hanging in with me as I went through that. So one of the questions that did come up in the chat is, can both parents be co-guardians? Yes. And a lot of families do that, that they would like to be connected and involved in that way. I know I shared my personal story and that we didn't want to create any more friction at that point, and just trying to be a 17-year-old and grow up. So we kept it that way. But yes, parents are co-guardians. The difficulty that could rise with that would be if there was some conflict between the parents, if the parents were not living together, if one parent was in another state, if my family member, if my son were in the hospital and needing approval on a surgery or some sort of medical treatment, and there was a dispute between the co-guardians, that would also be a source of a lot of tension and conflict. And depending on how the relationship is at that point between co-guardians, that could be that could delay medical treatment. It could end up impacting that relationship pretty negatively further. So that's something to think about, is how that relationship is and how co-guardians can back each other up on that too. If one co-guardian said, oh yeah, Robert should absolutely just walk through graduation and get his diploma now, he doesn't need the community transition program, and the other parent says, no, we need to do special ed until he's 21, that would be problematic. So the agreement piece between the co-guardians is really crucial in that. Absolutely. Are there some other questions? We could unmute folks if they weren't typing in the chat. I did the wrong thing there. Well, I'm not seeing any other questions come up. At this point, I'm going to wrap up and just thank everybody for participating, for sending the questions that you do have our direction. You are welcome always to call on the ARC, to email the ARC, and get a hold of myself or other folks in the Parent Coalition to find out more about this process. We are happy and often sit down with families to delve into some of the details on answering those questions further on, and also happy to talk about what does reporting look like. The rest of the guardianship packet that you have, those 123 pages from the courthouse, contain all the documents you're ever going to need. So it may be helpful for you to look eventually at what that report to the court form is. I don't have one in front of me right now, but there's so many of those same questions of the name of your family member, where do you live, has their medical condition changed, and then it just asks, in one page it has some very simple information of what kind of income has the family member had and how have those expenses then been covered on their behalf. So we can walk through that together. It's not quite rocket science, just a little bit of math, and is very similar to how you would keep track as a representative payee with Social Security. So I encourage you to go on the arcwhatcom.org website and find more information in that way. You can contact as well, you can contact the Whatcom Superior Court by going to the county courthouse, 3rd floor clerk's office. You can also call the courthouse at 360-778-5560. And over the phone, you can order a guardianship packet and pay over the phone. You can also talk with that courthouse facilitator or the guardianship facilitator and arrange to have a meeting with them and go over your paperwork. So those are some of the resources and supports that are available here in Whatcom County. And again, I want to thank my colleagues here at the Parent Coalition and the ARC of Whatcom County, Monica Burke and Barbara Roxas, my co-coordinators of the Parent Coalition, for supporting this training, and also thank Dave Reynolds and Connie Long with Whatcom County Superior Court for sharing information and guiding us through this process as well. And again, you can find us at arcwhatcom.org or 360-715-0170. Thank you, everybody. Bye now.